following is a paid program. The advice and opinions expressed during the program are solely that of Melick Law, not necessarily WBEV or Good Karma Brands. Welcome into Taking Care of Business. Today, Monday, first day back from Easter, we are here with Rob Melick and Melick Law. Rob, how you doing?
I'm doing well. How are you?
Doing very well.
Good.
Easter weekend passing, time to be with friends and family. Maybe a good time as well, because I know when I get together with family, you always start to talk about, okay, who have we lost in the past year? Who's not doing well? Whose health is where it's at? And then it always kind of leads to those conversations after the fact of, do we have stuff set up? Are we good? Are we okay? Yeah. Maybe a few people out there now thinking about how they should get things in line, and you're the guy to talk to for a lot of that.
You bet. And, it's unfortunate that Easter tends to be, it's a family gathering that's, an overwhelmingly positive and happy experience. But, yeah, that reflection does lead to kind of a secondary step of, well, do we have everything in order? Do we have the documents in place? And that's where I come into play as an estate planning attorney. That's the entirety of my practice, is creating documents, legal documents for both incapacity planning as well as post-death estate planning, where you want your assets to go upon your passing, making sure that they go to those individuals or charities as quickly, as easily, and as inexpensively as possible.
Now, I do want to welcome anybody who's listening to the show today. If you want to call in, if you have any questions for Rob Melick about estate planning, you'll do your best, of course, to try and answer them. Number 920-887-9595 is our call or text line. We have Jeff Hall on hand to get those texts to us. Or you can call us at 920-885-4446, and we'll be more than happy to answer those here. If you don't feel comfortable calling in on the radio and you want to call Rob Melick directly, let me make sure I got the number right here. I've got 262-347-3444.
That's correct. And I would also add that you can text me at that number as well. Some people prefer texting questions. That number is both the number to my office. One of my 3 paralegals will answer the phone, or that is a number that we can receive text at as well. So if you prefer to text a question, feel free to do that at that number as well. Again, just to repeat that number, 262-347-3444. Additionally, for most of the listening audience, my Beaver Dam location will be my closest for you. I do, Sandy and Matt graciously let me use their office to meet with clients. But I do have my main office in Saukville, which is just west of Port Washington. So if you ever want to get to that part of the state, nice area, a lot of good restaurants out there, pretty close to the lake. And I do also have offices in West Bend and Germantown as well. But that number, the 262-347-3444, that applies to all of my offices. And if you do decide to call, I always offer free initial consultations. There's enough barriers, there's enough hurdles to having people come in to meet with an estate planning attorney. I do not want costs to be one of them. So it's always a free initial consultation, and I do afford a 20% discount for WBEV listeners. So if you did hear us on the radio, or you did see the video that's going on, just mention that you saw us through WBEV, and we'll take a 20% discount as well. One final point is, in addition to the 4 office locations, I am happy to meet at your home. I have some clients who have mobility issues. I have some clients who simply either can't get or don't want to get a babysitter, in which case I could meet them at their home, or we could do it virtually. I offer initial consultations by phone, by Zoom, any other method. My goal is to make it as easy as possible. There's so many reasons why people do not want to meet with an estate planning attorney. So my goal is to make it as easy as possible to give you the information necessary to make a fully informed decision. Again, I'm not a high-pressure salesperson. I present facts, I present information, and let people make their own decisions. Because unfortunately, for whatever reason, I haven't been able to identify the cause of this, but for whatever reason, when it comes to estate planning, there's just so much misinformation out there. And I feel like it's disproportionate in that area of law compared to things like criminal law or family law or whatever the case is. There tends to be, we'll go talk to an attorney. Well, with estate planning, it's, you just do it online, or, this is what I did. You don't really need to go that far into it. And again, a lot of the misconceptions are wholly inaccurate, or they apply in situation A, but situation B is a little bit different, and that solution is terrible for situation B. So I do encourage you to meet with an estate planning attorney if you're choosing. Again, if you choose to work with me, we offer the free initial consultation and a 20% discount for WBEV listeners.
That's super awesome. And I want to make a point of mentioning this. You may have an office here and in other communities, but, you're very approachable. And you've got a very local flair to what you do. It means you're not dealing with somebody who's just an online voice in a chat room. You're not taking advice from somebody who's a faceless person. You're in and about the community. You do things in the area. As a matter of fact, I got to show this photo real quick. We've got you at a Brewer game.
There you go.
Catching a foul ball for a Brewers bus trip that you help sponsor here for WBEV. baseball fan, all around normal guy. You just happen to have decided to take your law degree and really focus it on a part of law that, like you said, has a lot of misinformation and that maybe a lot of people don't think about until it starts to get to be too late.
You bet. And it also allows me to dress like this as opposed to being in a suit. So
There
there's
go.
another positive to it too. And again, just the area of law, it's nice because I don't have opposing counsel. I don't have court deadlines. So I do feel like I was very lucky to get introduced to estate planning pretty early on in my legal career. Because again, for whatever reason, just the general public, there's a lot more knowledge about the medical field and the legal field. There's a lot of similarities between the two fields, but most of your physicians, they have a specialty. They go to a residency in a certain area. Now, certainly there are general practitioners, there are family doctors, but usually they specialize in something. Whereas the legal education really isn't that way. You get a law degree, and then the firm you go to. Now, certainly you may choose your firm based upon the specialties of things you want to do, but I'd say 95% of my classmates didn't know exactly what kind of law they wanted to get into. They got to a firm, they found what they enjoyed, and they kind of went with it. And for me, fortunately enough, that was estate planning. But again, I went to Penn State Law School. My graduating class was about 250, and I'm only aware of 2 other people in that class who do estate planning work. So none of my really good friends do it. They're all in different areas of the law, but I have found a niche here, and I really enjoy it because it allows me to do things like go to a Brewer game, and it was fun. Catching a foul ball was kind of neat. So it's a bunch of my buddies and that I talk to in group chats and everything. A lot of us were that. My one buddy in particular, he lives in Boston, and he's been to probably 100, 200 games. He's never caught a foul ball. And I've caught 8 during games. So I had to text him that picture. I'm like, I'm not extended the lead from 7 to 8 here. So I had to give him a little of the business about that. But no, it's I'm honored to sponsor the WBE bus out to the games, and we had a great time. I just don't do the July one because it's too hot.
It gets a little hot,
especially
at that point
in the bus. It's just the April one's good for me. Keep doing them in April. I'll keep sponsoring them. But once you get out into July, plus I coach football, so that kind of runs into that a little bit too, depending on the timing of it. So I stick with the early one, and I can wear a hoodie to the game, and I'll be fine.
Now I have to ask, because you mentioned coaching football. Again, you're out and about in the community. If people see you at a grocery store, they see you, whatever. How often do people come over and kind of give you that little, hey, real quick question for you. I have this, I have that. How do I keep this? How do I pass that on?
Yeah, not too often. It's more the, hey, you're my attorney. And again, what it is, in my practice, I'm blessed to have a lot of clients, and I'm not great with faces. I'm great with names. In other words, if you tell me a name, I could be like, oh, yeah, that's the person who had this distribution plan. Or, yeah, I remember that because they chose to have their immediately 18-year-old child be in charge of things. Like, I can remember those details, but faces, I'm not great at. So it does, I don't want to say frequently, but certainly occasionally it'll happen where someone will come up to me at a grocery store, at Walmart or whatever, and say, hey, Rob, how's it going? I'm like, good to see it. Like, I feel badly. And then when they introduce themselves, then I remember who they are. So yeah, no, that's just a part of small town practice that I really enjoy.
Now, let's dig in a little bit more into what we're talking about when it comes to estate law, because as we mentioned earlier, and we've talked about this a little bit in the past, there are a lot of misconceptions where people just think, oh, well, I've got a slip of paper, it's in the safe, my wife knows where it is, my kids have access to the safe, and it outlines in very exquisite detail who gets what and when and how and everything else. So everything's good, that's cut and dry, it's signed, it's been seen, maybe it's been notarized, whatever. Right. That's enough. That's good enough.
Largely unenforceable. Obviously, it depends on the contents of the actual document. I mean, to be clear, under Wisconsin law, you can draft your own estate planning documents. The question is, are they going to be enforceable? And under Wisconsin law, legal documents have to have certain formalities in order to make them enforceable. So if somebody just writes on I'm a big Simpsons fan, and there's an episode of The Simpsons where Abe Simpson, the grandpa, presents his will, and it says, everybody gets some but Homer. So obviously that's not enforceable, right? I mean, among other things, you have to have witnesses, notary, you have to have certain words in there that explain the person's of sound mind, etc. So again, if you do it on your own, it's not likely to work. And again, I tend to be big on analogies. I feel like analogies help people kind of understand concepts they wouldn't otherwise be familiar with. And the analogy I draw there is with respect to auto repair. Okay, and I know nothing about cars. I'm the least handy person you'll ever want to meet. So the idea is this: can you change your own transmission? Sure, you can. There's no law that prohibits you from doing it. If you do it right, you can do it. The problem is, how many people have the ability, the dexterity, the motivation, the time, and the knowledge to be able to do that correctly? I'd argue about as many who could do their own estate plan correctly. So there's a subset of people who have that, other lawyers, I've run into that quite a bit, although I do have a fair amount of lawyers as clients of mine who just like, I understand the importance of this. I don't do this work. I want you to handle my estate plan. So, because I do get that a lot. So yeah, it's a question of, it's not necessarily unenforceable just because it was handwritten, but the likelihood of being able to meet all of the formalities without legal training is pretty low.
And of course, you touched on it there with having even lawyers come to you. They understand that what you do is a specialty. You understand the nuances. You understand the little things that maybe you wouldn't necessarily understand from somebody who was a full-time criminal prosecutor, jury, trial, all that stuff. You're like, I know the generals. I went to school. I understand how it works. But maybe they're little nuances that you wouldn't get.
Well, for sure. And it's the same thing the other way around. Like, I know a little bit about criminal procedure. If I ever got arrested for a crime, I could defend myself, but I would never do it. I would hire someone who does this all the time and say, hey, defend me here. Do what you need to do to get me off the hook or reduce my sentence or whatever the case is. So there's an old cliche. I'm probably going to butcher it, but the client who has himself as an attorney made a bad decision or something like that. There's something like
as
a fool for a client. That's what it is. Yeah, I should know that, but I don't. But yeah, I mean, that's kind of what it is. So that is why a lot of attorneys, but I mean, I'd be willing to bet there are some attorneys out there who don't specialize in estate planning who do that. They look at the statutes, they figure it out. But yes, I do have a fair amount of clients who are attorneys as well. And that's actually not the most difficult group of people to deal with. My attorney clients are actually pretty easy. I'll put it out to you. There's one group in particular, of one profession that is very difficult. And again, nice people.
Right.
They ask a lot of questions and they are very precise and they require a lot of explanation. And that's engineers. So my engineering clients out there, I love you guys, but at the same time, you make me work for it. So keep me on my toes. So I like that. But they're definitely the most discerning of the professions out there. And make me answer the most questions, which again, happy to do. Making sure you get the explanations you need, because at the end of the day, that's what I try to do. I don't need to make my clients experts in estate planning. My standard is pretty basic. I want my clients to be in a situation where they understand why they have the documents and why they are better off for having them than not having them. If I can meet that threshold, I can do my job. But again, the idea here you mentioned before with misconceptions. So I'm just going to start there. I'm going to start with just some of the common misconceptions about estate planning, because what I've learned in my practice, again, first generation lawyer, I've been practicing for almost 18 years. I've had my own firm for almost 9, predominantly focused in estate planning. Certainly earlier on in my career, I did a lot of what I had to do to pay off my law school debt, commercial litigation, civil litigation, that kind of stuff. But I really have been, certainly in the past 12 years, and since I've had my own firm for 9, focused exclusively on estate planning. But one of the things I've learned is the main reason people do not want to, or people delay putting off an estate plan, has nothing to do with cost. It has nothing to do with the fear of their own mortality. I mean, those are two common things people would think of. What I found disproportionately, it is that there is a wide gap between what people think an estate plan can do and what an estate plan can actually do. Kind of to your point, the idea of the single sheet of paper is enough. And so when I have the opportunity, such as on a show like this, to explain what an estate plan can do, I usually try to take advantage of that so that people can understand and make fully informed decisions. And I don't care what we're talking. I mean, we're happy to be talking about estate planning here, but we could be talking about anything. Making any sort of decision. You can't possibly make a decision without full information. And the only way you can get full information is if you talk to experts, if you review things on the internet, things like that. But even on the internet, you got to be skeptical. Anybody can put anything on the internet. So one of the biggest misconceptions I run into here is the idea of when a power of attorney can come into play. So just to kind of set the stage here a little bit, because again, I know people who are listening or watching come at this from various perspectives, but to start with the basics here, okay, there are 2 types of powers of attorney. There's a healthcare power of attorney and a financial power of attorney. Relatively self-explanatory in terms of what they do. They allow you to nominate people who can make medical and financial decisions for you in the event of incapacity. But it's that healthcare power of attorney I want to focus on for 2 very large areas of misconception. And the first is for 18-year-olds. Okay, I'm just going to throw out a couple facts here that I don't have any scientific backing behind, but certainly anecdotally, I don't think anybody's going to quarrel with me on any of these. If you take the average 18-year-old in the state of Wisconsin, I'm going to state 3 facts about that individual that don't always apply, but they're present in the overwhelming majority of instances. 1, that person is a senior in high school. Okay, Majority of 18-year-olds, the day they turn 18, they are seniors in high school. Some aren't. I mean, I was, and I had a July birthday, so I graduated at 17, turned 18 right before my freshman year of college. But majority were 18 during their senior year in high school, one. Number two, most 18-year-olds still live at home with their parents. Again, some don't. We have some emancipated minors. We have some people who go off to the military, whatever the case is. But your average 18-year-old in Wisconsin lives at home. Third, the average 18-year-old is on their parents' health insurance plan. They allow them to stay on the plans till 26. So again, to summarize 3 facts about the average 18-year-old in Wisconsin, they're in high school, they live at home, they're on their parents' insurance. I use that as a backdrop to set up this point. If an 18-year-old drives to school or drives to a sporting practice or drives to a movie theater, whatever the case is, and they're involved in a horrific car accident such that they are taken to the hospital, they are in a coma, if they do not have health care powers of attorney in place, parents not only can't make medical decisions for them, they can't even receive information regarding the care and prognosis for the child who's in the hospital at that point, because sharing that information without the consent of the adult who can't give that consent if he or she is in a coma violates their HIPAA rights. So that's why I take the position that every single person over the age of 18 should have those powers of attorney. And I think intuitively you'd argue that if you polled 100 people at Walmart and you asked them that question, I think 90 plus of them would say, well, it's my kid. Of course I can make those decisions. Right. They live at home. They're a senior in high school. The moment they turn 18, we lose that ability unless we have a power of attorney. Okay? So that's misconception number 1 when it comes to powers of attorney. Misconception number 2, spouses. Okay, a lot of people automatically assume spouses have that right. I get in a horrific car accident. I'm taken to the hospital. I'm in a coma. Well, of course my wife can find out medical information. Of course she can find out how I'm doing. Of course she can make medical decisions. She can't do any of those unless we have a healthcare power of attorney in place. So again, that lack of information oftentimes causes people to say, what do we need powers of attorney for? But when you learn the truth behind that, when you learn the laws behind that, it changes people's tunes. They said, gee, I don't want to be in that situation. I don't want to be the parent of an 18-year-old who's in a hospital and I can't make those decisions. And again, fortunately, in this instance, this is a low probability event.
Right.
Most 18-year-olds are not going to be in a position to have to lose consciousness or be in a coma. But here's the indisputable fact. It's not 0% either.
Right.
It's somewhere north of 0%. And the problem is for any random 18-year-old, we don't know if we're going to end up in the overwhelming majority or the small minority. But by creating powers of attorney, you're taking that risk off the table. Financial power of attorney, another misconception there, is the idea that everything is jointly owned. People use the phrase Wisconsin's a marital property state. Everything we own is jointly owned. And I say, no, it's not, because there's 4, 5 really common types of assets that can't be jointly owned. Traditional IRAs, Roth IRAs, 401ks, 403bs, and life insurance. If you own any of those assets, by definition, they cannot be jointly owned. Now, a common response that I'll get there is people say to me, well, Rob, my spouse is the beneficiary. If I die, my spouse gets the money. My response to that is, that's great if we're talking about death. But we're not talking about death right now. We're talking about incapacity. So same example. I get in that car accident. I'm in the coma. My wife needs to use that IRA money to pay for bills while I can't work. She's the beneficiary, but I'm not dead yet. She can't use that money unless she has a financial power of attorney in place. So again, that further emphasizes 3 common misconceptions out there that oftentimes preclude people from needing an estate plan because they don't have full and correct information. But once they hear that information, it kind of causes some reflection to say, gee, I don't really like any of those scenarios. Right. I need to have these documents in place. So those are just 3 of the examples of common misconceptions just in the area of powers of attorney. Certainly when it comes to post-death estate planning, wills and trusts, there's a whole host of other explanations as well and other misconceptions also.
Now, unfortunately, a lot of those people, they learn the correct way that those things work too late in the moment, in the situation. Nobody wants to be the person who's, yelling at somebody behind the desk at the hospital saying, I need to see my kid, I need to know what's going on, I need whatever, right, and not having the ability to do so. High stress moments, all that other stuff. So what you're really doing is not only informing the public of what's going on, but you're also kind of I'm going to use this term and correct me if I'm wrong, but you're kind of a peace of mind salesman in a way, where what you're providing is a service that gives people that peace of mind if something happens, for going into the medical power of attorney. Yep. you know it's not going to be a concern. You know things are taken care of. And then when it comes to the financial side of things, it's also peace of mind to know that your family's not going to have that extra stress. You know, they're already going to be dealing with having you gone, whatever the case may be, and not having to worry about stressing about what do we do, what happens to the assets, where do things go. You know, that's got to be incredible.
It is, and it's a rewarding experience when people tell me that when the tragedy does befall them, that they knew they had these documents in place, and but for having met with me or heard from anyone else, they wouldn't have had these documents in place. So I know I'm providing a good service there. But I do like the peace of mind thing, and I do kind of want to tie that into another point that, again, is an argument by analogy, but tends to make sense. And I do sell peace of mind. I have legal documents that can provide people peace of mind in that time. And what I'd argue is it's very similar to another topic that, again, more people have more knowledge about, which is insurance. I mean, what is insurance doing, right? You're paying a sum of money to get a guaranteed event. Right. Now, if you never use that event, all you've done is pay in premiums. And I mean, let's face it, right? We were just talking about the Brewer game with the WBEV trip, right? Mm-hmm. Who sponsors the stadium? American Family Field. Right. I guarantee, and I haven't looked at their financials, but I guarantee you that they take in more in premiums than they pay out in claims, which enables them to be able to buy those stadiums and naming rights and things like that. So what does that mean? It means it's a bad investment. I'm not saying don't do it, but I just look at it from the peace of mind standpoint. Homeowners insurance, that's not legally required. Auto insurance is, right? In order to legally operate a vehicle in the state of Wisconsin, you have to have auto insurance. Now, some people ignore that or choose to not comply with it, but it's a legal requirement. Homeowners insurance is not. Now, it's oftentimes a contractual requirement. If you have a mortgage on a home, the bank's saying, hey, look, we own part of this home too. We are going to require you as a condition for us continuing to lend you money that you maintain homeowners insurance. But once that mortgage is paid, it's not legally required. And I've used this example for about 10 years, Ninja, and I have never once found someone who said, you know what, the day I paid off my mortgage, I called my homeowner's insurance company and canceled my policy. Right. I have never seen it. If that person exists out there, I'd love to meet you and learn what your thought process was. Not judging, because, I mean, financially, it's the right decision. Right. Statistically speaking, you are going to pay significantly more in premiums than you will ever get in claims. But I've never met anybody who does it because they want the peace of mind.
Right.
I think that's a perfect analogy to estate planning. The difference with estate planning is this is an event that is going to occur when we talk about death. In other words, incapacity may or may not ever happen. Low percentage of 18-year-olds or 19, 20, whatever you want to do, are going to become incapacitated. But I don't have the statistics, but I can just say anecdotally in my practice, most of my clients become incapacitated at some point in their lives. Okay, whether it's a car accident, whether it's development of Alzheimer's, dementia as they get older, most people become incapacitated. So that's an event that is going to occur for a lot of people at some point in their lives, whereas death is 100%. Right. We're all going to pass away. So the risk assessment we're looking at is different there. But when it comes to post-death estate planning, that's where we really start talking about the differences between wills and trusts. And again, I feel like that's another large area of many misconceptions when it comes to estate planning.
And before I jump into the question regarding that, because I know I want to talk about that as well, is there a legal definition for incapacitated? Because I think of like incapacitated as like, okay, they're in the hospital, maybe they're so medically banged up that they can't make sound judgments, or maybe they're in a medically induced coma or something like that where they can't respond. Yep. That's my first thought. Yeah. But are there other things that might fall under that?
Yeah. Under Wisconsin law, basically the idea of legal incapacity is you have two or more, either two physicians or a physician and a psychologist who sign a document saying that in their professional opinion, this person lacks the ability to receive and process information. That's the standard. Now, that could be temporary, right? I could get in a car accident on the way home today and be in a coma for 2 weeks, and then I go back to being capacitated. Or it could be Alzheimer's or dementia where I don't have that capacity anymore. So it really does vary. But it does require those two medical professionals signing off that they believe that. And that, for lack of a better word, activates the healthcare power of attorney. Until the two medical professionals have signed off on it, that healthcare power of attorney is dormant. It's not active at that point in time. I mean, I have a healthcare power of attorney presently, but it's dormant. I have capacity. I'm talking. There's no doubt that we have capacity here. I'm not a medical doctor, but I know you have capacity, right? So it's one of those things where sometimes where it's more gray area, that's where the physicians and the medical professionals have to come in, because I'm sure every single person in the listening audience has heard the phrase when describing elderly individuals, they have good days and they have bad days. Mm-hmm. Well, I'd argue as non-elderly people, and I'm not going to put you on the spot too much, I mean, I'll certainly reflect it on me, but think about the sickest you've ever been in your life, okay? Mm-hmm. The worst pain you've ever been in your life. if you were asked that day to make serious financial decisions, how good of a job would you do? I'd argue pretty poorly.
Yeah, I'm pretty
Right.
distracted at that point.
Well, that's what I'm saying. And you're just not thinking clearly. I mean, I can think of times I've been sick. I can think of times when I've been in a hospital. I was never incapacitated, but I wasn't in a great state of mind at that point. I mean, I was not able to make those decisions, but legally I would still have capacity because I can understand those types of instructions, but I wouldn't want to be making decisions during that time. I'd want to wait until I felt better to make those decisions. So those are all things that you have to look at, but that is the definition of legal incapacity.
Now, moving on from that, I want to dive into, we were talking a little bit more about the estate planning stuff, and there's a word that we use that gets thrown around a lot, and it's a word that I've learned to find very scary, and that's the word probate.
Yeah. So why don't we give a basic definition of probate? Again,
Let's
you're
do
right. I'd be willing to bet 98% of the people in the listening audience have heard the term probate. But let me give a one-sentence definition. Where I can in my practice, I try to give one-sentence definitions to make things easy. Probate is the process where a court oversees the administration of an estate. That's really what it is. Probate is where a court oversees the administration of an estate. When an estate goes to probate, there are a series of hearings, a series of filings, a series of deadlines, a series of events that occur before assets go from the name of the deceased to the name of the intended beneficiaries. Simply put, my goal as an estate planning attorney is to encourage my clients to create plans that are guaranteed to avoid probate. Okay? Not possible, not highly likely, but guaranteed. Why? Why is probate avoidance so important? 3 reasons. First is cost. Average cost of probate in a state right now in the state of Wisconsin is between $8,000 to $12,000. Secondly, time. Average length of probate is 12 to 18 months. Third reason is publicity. The will becomes public record upon passing when it goes to probate. Not only does the will itself become public record, but the amount and the character of the assets passing through probate also become public record. So to summarize those negatives, cost 8 to 12 grand, timing 12 to 18 months, public record. The key question is, how do we avoid probate? And this is the source of a lot of misconceptions. And I'll start with this basic premise that I get from a lot of my clients. I have beneficiary designations on all my assets. Therefore, it's guaranteed to avoid probate. That is false. And I'll explain why it's false. First of all, there are many types of assets that people own that we can't list beneficiaries on. Commonly, vehicles, jewelry, appliances, tools, furniture. There's just no mechanism to list a beneficiary for those.
Right.
Okay. The second part is this. Let's assume that the value for this hypothetical family of those assets in the aggregate is less than 50 grand. Can I still say the estate's guaranteed to avoid probate? The answer is no. Why? Because I have no way of knowing whether any or all of the beneficiaries will survive that person. For example, I have the 2 boys, 2 sons, 15 and 12. By definition, I'm a generation older than they are. They should survive me. I hope they survive me, but it's not a guarantee. And in fact, I'm not going to know the answer to that question until the day I pass away.
Right.
What I can tell you, though, with the trust is with 100% certainty, the trust will survive me because the trust can't die. And that's why I encourage my clients to consider trust-based planning, because you're getting the guarantee. No differently than the homeowner's insurance is guaranteeing you the outcome of guaranteeing that if the home does happen to burn up or does happen to be a loss, that you're going to be made whole. That's what the trust does. The difference between trust and homeowner's insurance is that with homeowner's insurance, you have to pay that premium every single year. You miss a year, you have that incident that year, you're out of luck. At least at my firm, and I can't comment on how other attorneys do it, but at least at my firm, when it comes to trust-based estate planning or will-based estate planning or powers of attorney for that matter, you pay one fee and it's done. There's no ongoing fees, there's no maintenance fees, and I don't even charge for revisions at my firm. So if you do a trust-based estate plan with me, those revisions are done on a complimentary basis. So your estate planning costs are set at that point in time to get that guarantee that regardless of who happens to pass away when, the estate's still going to avoid probate.
Before I ask my next question, I do want to remind everybody this is a paid program. The advice and opinions expressed during the program are solely that of Melick Law.
Through the time and effort of creating a trust, the state wants to make sure that assets are distributed in an appropriate manner consistent with the intention of the deceased. So probate occurs when you have more than $50,000 worth of probate assets, and for most people, the equity they have in their home alone well exceeds $50,000. But it also occurs in instances where people do not have an estate plan in place. And then there are what are called heirs at law, which are basically next of kin. So the court and the state laws determine where assets go based upon who is next up in your family tree. So that's why the state takes an interest in it. They want to make sure that beneficiaries' rights are protected. They want to make sure that the wishes of the decedent are honored. And they feel that the courts need to be involved in that process to make sure that happens, unless you privatize it by creating a trust or if you have less than $50,000 worth of probate assets.
Now, when we talk about things that go through probate, one of the things you mentioned is that the nature of the asset is public.
Right.
So is that like oh, well, Ninja Pass turns out he's got, $20,000 worth of comic books.
Right.
And that's getting passed on. So
You
now
bet.
everybody knows I was a giant nerd.
Well, not only a giant nerd, but what if someone tries to break in your house and steal those comic books now that they know you have $20,000 worth of comic books?
Right.
So that's all public record. I mean, I'm sure most people in the audience have heard of CCAP before. I mean, most people use CCAP for criminal or quasi-criminal issues, but it's Circuit County Access Portal. I mean, included but not limited to estate planning documents when the estate goes to probate. Those are public record documents. Absolutely.
It's a little scary to think about.
Well, and
People could just search that up and
well,
look.
well, and especially when it comes to minor kids, right? I mean, that's the other thing too. It's not just if I die in 40 years and I leave everything to my kids, okay, they're grown adults at that point. But if I die tomorrow and it goes to my kids, they're going to know a 15 and 12-year-old. They're going to know exactly what they received. They're going to know exactly what it looks like. Maybe there's some nefarious people out there who may take advantage of that.
Well, and you've mentioned that's one of the benefits of the trust-based planning as well is you can say, well, if I were to pass tomorrow and my kids are as young as they are, that they're not suddenly being handed a bunch of wealth while they're, I hate to use the phrase, but young and dumb and don't know how to handle it.
Absolutely.
Whereas you can set stipulations and all that.
You bet, because that's the hidden understanding when it comes to that. You're exactly right to mention that. When it comes to a will, and what I'm about to say may seem, I guess, controversial in a vacuum, but it's 100% legally true. A well-drafted will should have as few assets as possible passing through it, because for a will, we want to have named beneficiaries. But if we have named beneficiaries, they get the money right away, as long as they're at least 18.
Right.
But a lot of people want the kids to wait till 21, 30. I had one the other day, it was 45. They wanted the kids to wait. So I wouldn't be able to receive benefits under that plan. But, and that's my point. So that's yet another benefit. Half at 30. You do it however you want. Whereas if you're having a will or solely creating a will and you're relying upon beneficiary designations, you don't get that same ability to control the money.
Now, when somebody is laying out their final plan with you and going through that trust-based planning, is it common for them to put like specifications in there for why? Like, for instance, let's say I've got 3 kids and I know kid 1 is good to go. They're going to take care of everything. They're the most responsible one I've got. The other 2 kids might need a little more help.
Yeah.
And so how I lay things out is, we're going to help these ones a little bit more, but I know they're going to be good. Do people put little personal comments in there, little explanations, or do they stick just to the...
Yeah, typically not, but I do encourage my clients to give an explanation verbally to their children. Because again, I'm not here to judge, but I use one example here where I had a client who decided to give more money to one child than the other because in his opinion, he gave more money to the child who's receiving less at death, or during life. So the idea was he gave more one during life, he wants to give the other one more at death to make it even. And my advice to that person was I'd have a conversation with your children explaining that, as opposed to you waking up dead one morning and they see your trust and they see a disparate distribution, wondering, well, did dad not love me as much? Like, what happened here? So having that verbal explanation makes sense. But what I do simultaneously encourage my clients to do is it's your money. It's your estate. You worked hard for that. Don't let a kid talk you into a change in your distribution. I mean, to me, that's a pretty private matter. I mean, sharing the information, sure, but it's not getting advice from them on how assets should be divided. It's this is how it's going to be. I'm letting you know this is how it's going to be because at the end of the day, it's your estate plan. It's your money. You can leave it to whomever you want. There's no such thing as birthright in Wisconsin. If people want to leave every single penny they have to the Humane Society and disinherit their kids, they absolutely have the ability to do that.
Leave it all to their cat. Instances in my past where I know people have passed, and then it becomes an argument of, well, we got the will, we read the will, we did whatever, and grandma and grandpa left the house to so and so, and no, we always talked about it was going to be this. I don't know why it's this. They must not have gone in and changed it. Whatever. They argue, they fight. It becomes this big legal issue. Is that because it's will or because of how it's? Or do you even see that sometimes with trust-based where people try to dispute?
You do see it, but I put provisions in my documents to say if anybody contests this, even if they're successful, they receive $1 and nothing more, as a means to discourage people from contesting it. Now, with that said, I run into that, verbal promise. Well, verbal promise and 50 cents will get you a can of Coke. I mean, it's not enforceable. So that's the issue. So what I do suggest there is if people want to make changes, they got to get it done right, and they got to get it done sooner rather than later, because if you forget and you run out of time because you pass away, then the documents are what they are.
Now, is there wording that can be put in? Because I think about, if I come see you and, we get everything set up and, 5 years from now I do a little revision because there's some added assets or whatever. And then 10 years from now something happens and it's been 5 years since I've talked to you.
Right.
Assets have changed, things have been added, things have been removed, whatever. And then that might not be the most accurate document anymore that we have in place. Do you put wording in that kind of adjusts for that, for those inevitabilities?
I mean, not really. I guess the way I look at it is I verbally encourage my clients, especially since I don't charge for revisions, to say, hey, look, if there is something that comes up, let me know. And I really divide changes into kind of two categories: legal changes and preference changes. Legal changes are on me, okay? It's my job to let my clients know if there's some sort of legal change. Like, for example, this is the most common example I can give. At present, Wisconsin does not have a state inheritance tax, okay? If that changes down the road, then I got to let my clients know that.
Right.
I'm not expecting my clients to know that Wisconsin has now adopted an inheritance tax. So if that changes, then it's on me to notify my clients, say, gee, Wisconsin just adopted blah, 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 inheritance tax. If you want to know how, if at all, that impacts your estate, schedule an appointment, no charge, and we'll figure it out. Because it may be a dollar figure. Like, for example, and again, I am making this up. There's no evidence to my knowledge that this is happening. Please, to be clear, is let's just say Wisconsin says, all right, federal inheritance tax starts for a married couple at $25.8 million. Let's say Wisconsin adopts a $10 million inheritance tax. Well, if my clients don't have more than $10 million worth of assets, it doesn't matter. So that's the first thing I would say. I would probably write a letter, but I would say, as long as your net worth is less than $10 million, please disregard this letter because it's not going to apply to you. Because I don't know what my clients have. I mean, I certainly am not going to remember it. I mean, it'd be one thing if I met with somebody, they may present me with an asset sheet, but I'm not going to remember that 5 years from now. I mean, I have a pretty good memory, but I don't remember that. So I would just put in categorically, look, this is who it applies to. Or, I'm sure you've heard the term grandfathering before. Maybe this hypothetical law comes out and it grandfathers people. If it grandfathers people, and I don't need to worry about anything because these documents were executed before this hypothetical law change, right? So it's one of those things where, depending on the nature of the law change, that guides the advice that I give to my clients. But preference changes, I have no control over. I don't know what private events are occurring in your life that may cause you to want to update your documents. I have no idea. But I encourage my clients to say, look, if something comes up, let me know. And again, I don't charge for those revisions, but you got to let me know what the nature of the revision is, and then I can give you legal advice on the best way to accomplish that change. Because there's some changes that do not need to occur. By far the most common one I get, to update the documents. They can identify by the former last name. I have no problem with that. Address changes. I don't care about address changes because we're not sending letters to anybody. Now, if you as the client's address changes, well, then I got to know that just so I know where to send things and letters and updates. But as far as the underlying enforceability of the legal documents, address changes, addresses are identifiers. Just in case there's multiple John Smiths out there, we want the John Smith who lives on Main Street, not the one who lives on Elm Street, whatever the case is. Phone numbers, absolutely. If there's any phone number change, we got to make those changes immediately, because if there's a medical emergency, you have a phone number on a healthcare power of attorney, and it's the wrong number, that's not very helpful.
Yeah, they're not going to go hunting around for the right number.
That's exactly right. And they're not going to send a letter either. So, I mean, they're going to move on and figure out what they need to do. So when it comes to those changes, I always encourage my clients, call my office. Like I said, I don't charge for those revisions. You let me know what you want to change, and we figure out the best way to accomplish that change.
Now, a lot of people out there, when it comes to future planning, they might be thinking about retirement planning. And that's one thing that's kind of a big focus with people right now, especially people I've been talking with who are getting into my age, that early 40s, mid 40s, is starting to think about, I've got less work years left that I've put in at this point.
Sure.
How well does that tie into estate planning? Should they, if they're thinking about one, should they definitely be thinking about the other?
Absolutely, and that's one of the many reasons why I work so closely with Hire. The ability to know that Social Security optimization, Medicare, retirement, all of that plays in. And again, the analogy we use there is we're all on the same team. We all specialize in our different areas. We all focus on different areas. But the goal, of course, is we're all working together for the common goal of helping that particular client. So absolutely, from a timing perspective, it's a good idea to make sure all of that is in a row. So again, talking to hire about Social Security optimization, Medicare, retirement planning, the rollovers, things like that. Those are all services that hire can perform, and they do a great job. So that's why I'm proud to work with them.
Now, if people go with a trust-based plan, can they name that as the beneficiary for life insurance and things of the sort?
They can, and as a general rule, and there's some exceptions to this rule, but as a general rule, I recommend listing the trust as a beneficiary on everything except retirement assets. Because when it comes to retirement assets, there are tax consequences associated with those that, again, vary on a case-by-case basis, but for the overwhelming majority of my clients, the only class of assets we don't list the trust as a beneficiary on would be those retirement assets.
Let's talk a little bit about taxes. Is there any difference as far as if somebody goes with will-based, trust-based, whatever, as far as how those assets are taxed for the person that gets it?
Nope, they're tax neutral. I mean, the only exception would be putting retirement assets as the trust as a beneficiary. Trusts would pay out at the trust tax rate as opposed to human beneficiaries who, at least under current law, have up to 10 years to absorb the tax consequences. So there could be a difference there. But again, with proper estate planning, we're going to make sure that the human beneficiaries get up to 10 years to take those tax consequences as opposed to earholing them to the trust.
Now, not to wrench your arm into a time frame, but if people were trying to think about okay, well, how long does it take? Because I don't want to spend weeks and weeks and weeks sitting down talking with you, going through everything, outlining all my, but I also don't want this to be a 3-minute over a cup of coffee.
Yeah. Here's what I can tell you. And again, it's your mileage may vary, right? But what I can tell you is that the garden variety client, first thing you do is you schedule an initial consultation. Again, that's always free. Happy to do it at any of my 4 offices, Beaver Dam, Saukville, Germantown, West Bend, by phone or by Zoom. You schedule that initial consultation. My average initial consultation takes about 30 to 45 minutes, give or take, where I just educate and inform about the differences between wills and trusts, the importance of powers of attorney, learn more about their situation, come up with a flat fee price. Okay, assuming the clients decide to go forward, what I typically do at that meeting, and this occurs probably 95% of the time, is I conduct my initial intake interview there. I just ask a bunch of questions that give me the information necessary to draft the documents. Usually takes me about another 10, 15 minutes. It takes my office about a week and a half to 2 weeks to draft the documents. We schedule the signing thereafter. And the signing typically takes about a half hour. So in terms of time investment on your end, you're looking at about an hour-ish, give or take, between the signing and the initial consult, and then about 2 weeks from initial consult to the signing, depending on your timing, your schedule, your motivation.
And the services you offer, be it the medical power of attorney or the will-based planning or the trust-based planning, obviously you don't need a will and trust-based, right? It's one or the other?
A trust-based estate plan includes a will, if that makes sense, because the will just basically says see the trust for distribution. But yeah, basically it's a choice, will-based plan or trust-based plan. That's
so
correct.
If I come to you and I set up a will-based plan and I get that going, I feel like that's all I need for right now. I can come see you again in the future if I say I need to upgrade this to trust-based.
And not only can you do that, but I afford a built-in credit. So whatever you paid for the will-based plan in time 1, I defray from the cost of the trust-based plan in time 2. That way you're not double paying for services.
That is really awesome. We have about 2 minutes left. I want to give you a moment to just once again let people know how they can find you online, Facebook, wherever you happen to be, all the phone numbers so that we can make sure people can reach out to you if need be.
Yeah, absolutely. So for most people in the listening or viewing audience here, my main office would be, or closest office would be the Beaver Dam office that I use with Sandy and Matt's blessing right at the I think it's still called the Heritage Mall.
Yeah, I believe so, yeah.
Next to what is now going to be the soon-to-be closing Joanne Fabrics. So right next to that in the old Slumberland. It's kind of nestled between those two there. But I do also have my main office in Saukville. So if you want to see the headquarters of the operation, come on out to Saukville. About an hour-ish minute drive from here. But it's straight shot on 33. I mean, if I was a good golfer, which I'm not, but if I was a good golfer, I could hit a golf ball from my office to Highway 33. That's how close it is. So
I like it.
But I wouldn't be able to do it because I'm a terrible golfer. But anyway, also offices in Germantown and West Bend, free initial consultations, and 20% discount for WBEV listeners or viewers. And finally, I do offer the complimentary revisions on the documents. So you create a trust-based estate plan with me. Changes are done on a complimentary basis at that point in time. Best way to get a hold of me is by call or by text, 262-347-3444. Again, 262-347-3444. My name is Rob Melick, Melick, in case you're trying to Google me. You can find me there. I do have a website as well, which is just melicklawwi.com. So it's melicklawwi.com. So there's two W's, the W in law and the W in I, or the W in Wisconsin. So again, melicklawwi.com. And yeah, that's the best way to get a hold of me. And that number that I mentioned again, 262-347-3444, that's available 24/7. Either myself or one of my paralegals.
Very informative. And I do know somebody, I'll let him remain nameless, who was kicking the can on coming to see you for quite a while. And the discussion I had with him today makes me think I should probably not kick the can nearly as long as he did.
You bet.
So we do thank you for coming on, being very informative as always. And we look forward to seeing you again here soon.
Good seeing you as well.
This has been a paid program. The advice and opinions expressed during the program are solely that of Melick Law, not necessarily WBEV or Good Karma Brands.